Now, I gave Senator Kennedy an extra couple questions in the last round on condition that be nice to all of these folks. So with that, Senator Kennedy.
I'm always nice. How many of you worked for Senator Schmidt? All four of you. Is it true that he was suspended 23 times in junior high school in February alone?
They're under oath.
Look, I'm not trying to trick you. I'm not going to ask you how you rule on cases, and I'm not going to ask you about your political beliefs. I just want to know how you think. Let's start with the counselor on the end. Let's suppose I'm a cop, and I'm on duty, and it's 3 o'clock in the morning, and I see somebody driving down the road, many other people around. It's on a Saturday night. Can I stop him?
Just because you see him driving around?
Yeah.
There would need to be more of a basis than that.
So the answer is no.
Correct.
Okay. Let's suppose that I recognize him, and on 3 previous occasions, he's been caught for charged with DWI, but he's not driving erratically. I'm the cop again. Can I stop him constitutionally?
Same answer. No.
No.
You would need more than that to be able to conduct an investigation.
Why doesn't that give me reasonable suspicion?
I think merely the fact that he was driving at 3 a.m. and had been pulled over previously for driving under the influence wouldn't be enough. Now, it certainly, if he were swerving or driving improperly in some other way, if he committed a traffic violation or something along those lines, certainly the officer would be well within his rights.
So we can agree our privacy is precious to us, even if we're in a car, right?
I would agree that the Fourth Amendment very thankfully protects us all from unreasonable searches and seizures.
So how come the cops can set up a roadblock and stop everybody when they don't have either reasonable suspicion or probable cause, just to check and see if they have insurance?
So there are limitations on scenarios like that.
Hello, viewers, fellow defenders of liberty. Welcome back to the American Enigma, where we hold the line, speak the truth, and stand tall for the Constitution of the United States. Now, on today's episode, we're looking into a fascinating, yet deeply revealing, exchange between Senator John Kennedy, God bless him, and a panel of judicial nominees. If you haven't seen the video, you need to. This isn't just about a few judges answering questions. This is about how the people in black robes, those who are supposed to uphold the Constitution, actually think about our rights. Let's break it down. That's classic Senator Kennedy. Lightens the room, makes a joke, but he's setting the tone. He's not here to play games. He's here to test how these folks think. And that matters because judges shouldn't be activists. They should be constitutional referees. Now Kennedy says, let's say I'm a cop. It's 3 a.m. I see a guy driving alone on a Saturday night. Can I stop him? And what do all the nominees say? No, you need more than that. Can you imagine?
But can they do it first, Counsel? I mean,
officers can set up roadblocks if they are applying it based on a neutral and articulable standard, and if that standard relates to something that is specific to automobiles. So they could not stop every car to search.
You're right about the law, but why is they don't have reasonable suspicion. They're stopping everybody. They certainly don't have probable cause. It's intrusive. I mean, I can spend 10 minutes in line for them to check my insurance. What's the basis for that being constitutional?
I think the way I would frame it is that the courts have decided that scenarios like that, and in scenarios like that, officers would not be acting unreasonably. So they would not be violating somebody's Fourth Amendment rights.
Because the Fourth Amendment
guarantees
prohibits unreasonable searches and seizures.
Correct.
And how do you determine whether something's unreasonable or not?
Well, I think that would very much depend on the situation, the specific facts and the context.
Don't you balance the costs and benefits?
In a scenario like that, yes.
Okay, cool. Judge, what's the rule now that the Supreme Court follows on reapportionment cases? Congressional redistricting.
Congressional redistricting. My understanding, Senator, is that the Supreme Court has decided that that's a political issue, and under the political issue doctrine that essentially the courts really don't have much of anything to say about political redistricting.
If Missouri's legislature gets together and it redraws districts, and they're, let's say, a majority of Democrats in the legislature, so they say, we're going to redraw these districts to benefit Democrats, and we're not going to be reluctant to say so. They say it in front of God and country. Is that okay?
Well, it's pursuant to the Supreme Court precedent. It's legal.
Yeah. Okay. All right. I'm not going to get to all of you. Counselor? This counselor. Yes, ma'am. Do you think the meaning of the Constitution is immutable?
So I think that the U.S. Supreme Court has said that
I want to know what you think.
So, yeah, my view in terms of like what it is that, you know, my way of looking at the Constitution is to say, what does the text say, and what did it mean at the time that it was passed? And this is something that the U.S. Supreme Court also says. If that's not clear, I think there are other things you can look to, like history and tradition, to decide what the
You
text
look
means.
to what it meant at the time it was passed?
Correct.
What it meant to whom?
To the people who were passing it.
To the people who wrote it?
So I think there are various different ways of looking at this, and I think the U.S. Supreme Court has said that you look at the meaning that the words would have to the public at the time that the Constitution was ratified.
That's right. I'm done. Thank you. Congratulations.
Senator
Now listen, I understand we don't want police harassing innocent people, but here's the issue. They're ignoring common sense. At 3 in the morning on a Saturday night in a known area for DUIs, if you've got a history, shouldn't that at least raise reasonable suspicion? We ask our police to keep us safe, but then we tie their hands behind their backs with legal jargon. That's not protecting rights, that's putting everyone at risk. This part really gets me. Senator Kennedy says, why can cops set up roadblocks to check for insurance if they don't have probable cause or reasonable suspicion? Great question, Senator. Now, the nominee says, well, courts have ruled that it's not unreasonable. Excuse me? Since when do we decide what's constitutional based on whether some court thinks it's not that bad? Here's the thing. The founders were crystal clear. The Fourth Amendment protects us from unreasonable searches and seizures. The standard isn't neutral and articulable. It's constitutional or not. We've allowed this creep of judicial wiggle room, and it's eroding the wall between citizen and state. Let's talk about redistricting. Kennedy asks if a state legislature can redraw congressional districts openly to benefit their party. The answer? Yes, it's legal. Now here's where I agree partly. The Constitution gives that power to the states. Period. Not to federal judges. So when the nominees say, the courts stay out of it, they're right. But here's my issue. The only reason the left ever complains about gerrymandering is when they're not the ones doing it. If Democrats control a state, they'll draw maps to win. And when Republicans do it, suddenly it's a threat to democracy. Folks, it's not about fairness. It's about power. And that's why we must hold firm to the principle of federalism. Let states govern their own elections, and if the people don't like it, vote them out. Here's the grand finale. Kennedy asks the nominee, is the meaning of the Constitution immutable? Translation. Does it change over time? Or does it mean what it meant when it was written? And what does the nominee say? She tiptoes at first, then admits, I look at the text and what it meant at the time it was passed. Finally, some honesty. That, my friends, is originalism. That's what Justice Scalia stood for. That's what every judge should stand for. Because if the Constitution means whatever a judge feels like it means in 2025, then we're no longer ruled by law. We're ruled by the whims of unelected elites. The founders didn't write a living document. They wrote a contract, a covenant, one that is supposed to restrain government, not bend to modern ideologies. So what did we learn from this hearing? We learned that Senator Kennedy is a national treasure. We learned that many judges know how to recite precedent, but few can articulate why it matters. And we learned that our rights, our God-given, hard-won, blood-bought rights, are hanging in the balance every time a new judge gets confirmed. This is why elections matter. This is why judicial appointments matter. This is why you, the American patriot, must stay informed, stay vocal, and never stop fighting for liberty. If you believe in the Constitution, not a twisted version of it, but the one our founders wrote, then subscribe, share, comment, and like this video, and keep standing strong. Until next time, see you on the next episode.